Good morning. Hello everyone. I would like to express my deep appreciation to the President of the General Assembly for inviting me to present as to how earth jurisprudence has been unfolding in India. The ethos and philosophy which serve as a beacon light for Indian environmental law has been in vogue for many a century. Embellished with numerous traditions and customs, often pointed out by judges, these have been the very basis of the law. India became independent in 1947 and enacted her constitution in 1949. But it was only in 1976, by virtue of the 42nd constitutional amendment, that two specific provisions relating to protecting the environment was read into it. Likewise, it was only in the 1980s that one could witness a liberal interpretation of the right under Article 21, which spoke about the right to life and personal liberty, starting with the 1985 RLEK case, wherein a discussion on few notions about environmental protection was present. The right to live in a healthy environment was read as a specific right under Article 21 in the 1991 Subhash Kumar case. Courts in India have grappled with cases which had posed intertwined questions about customary practices and environmental conservation. For example, in the 1996 T.N. Godavarman case, the Supreme Court had opined that environmental justice could be achieved only if we drift away from the principle of anthropocentric to ecocentric. Time and again, one notices that the Supreme Court has highlighted the socio-cultural importance that protecting the environment does imply, and figured out ways to incorporate them into law, and thereby developing an ecological sense. The decision rendered in the 2013 Niyamgiri case, wherein mining activities on a mountain, revered by local communities, were stopped, opened new doors. Further, there have been instances of the court holding that animal welfare laws have to be interpreted, keeping in mind the welfare of the animals, which in turn secured them rights. One can, with conviction, say that the decisions rendered in 2017 in the Mohammad Salim and Lalit Miglani cases, where similar rights as those provided for humans were given to natural entities, opened a new chapter in environmental jurisprudence, stressing on ecocentrism. Any harm caused to these entities was to be treated akin to harm caused to humans. These cases provided for a legal personhood being afforded to two rivers, as well as a legal entity status to natural entities. There have also been various High Court decisions, for example, the 2018 Narayan Dutt Bhatt case, wherein the Uttarakhand High Court afforded legal entity status to the animal kingdom and cast a duty on the citizens of the state to act as loco parentis. The Punjab and Haryana High Court in the 2019 Karnail Singh case reiterated the same. In the 2020 Sukna Lake case, the same court held that the Sukna Lake is a legal entity and secured its rights. Courts in India, in line with international developments, have gone for recognition provided in a specific case rather than providing a blanket right. An amicus curiae is appointed to speak for the entities, and the guardianship principle, coupled with a public trust doctrine, has opened up newer avenues. They have also ensured that ample public participation is secured by reading it as a fundamental duty, thereby fostering ecocentrism. The Supreme Court of India has an opportunity to delve into the matter as a public interest litigation has been filed by an NGO, the People's Charity Organization, to extend legal personhood to the entire animal kingdom, and the matter is under consideration. In conclusion, whatever be the path that is being chosen, one can only hope that the court takes due cognizance of the many developments that are happening worldwide on earth jurisprudence and remain open to a new chapter in law, a purely ecocentric approach where humans are one among various components of nature. Thank you for your attention.